Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this argument of the Kansas Supreme Court. We welcome counsel. We have read your briefs and are looking forward to your arguments. We also welcome all of those of you who are watching through our Supreme Court live channel. We do have some faces that are not necessarily familiar to you as you look at the court typically, so I do want to make some quick introductions. First, although he's now into his fourth day, I still continue to want to make sure everybody welcomes our newest colleague to the court, Justice KJ Wall, who is sitting on his first docket with us. Second, also becoming more and more familiar, is the senior judge assigned to our court. We are looking at the impending retirement of Justice Carol Beyer, effective tomorrow. So she is not sitting with the court this week, but we are pleased to have the able assistance of Senior Judge Mike Ward. Judge Ward was formerly a district court judge and has been assigned to our court as senior judge since March of this year. And finally, in this case, Justice Biles has recused from the hearing this case. And so sitting for him by appointment today, we have District Court Judge David Hauber. Judge Hauber has sat since 2008 in the 10th Judicial District, which is comprised of Johnson County, Kansas. Judge Hauber is a very busy judge with an active docket there, and he has taken time away from that to assist us today. He has read the briefs. He will participate in our consideration and discussions of the case and follow through until that decision is filed and the mandate is issued. So he does give us quite a bit of his precious time, and we appreciate his willing assistance. Thank you, Judge Hauber. With that, I will ask the clerk of the appellate court, Mr. Doug Shima, to please call the case to hear next.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, September 17th, 2020 consists of one case, appeal number 117725, Howard Johnson III versus U.S. Food Services et al., workers' compensation appeal, briefs both sides. This case is on petition for review. The argument is set for 15 minutes each side. The appellate petitioner is U.S. Food Service et al. And the Office of Kansas Attorney General as intervener. Will split the initial time 6 minutes each side, and then 3 minutes rebuttal by the Office of the Attorney General. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. As Mr. Shima just said, both petitioners, the appellee and the intervener, will be splitting their time. And as I understand it, Ms. Haskin, you will begin the argument. So you may now, after I ask you to state all counsel to state their appearances, we will proceed in that way. So if you would now state your appearances, please.
Yes, Madam Chief Justice, may it please the court. Michelle Haskins, attorney for U.S. Food, appellee and petitioner herein.
May it please the court, Assistant Solicitor General Dwight Carswell, appearing for intervener, Office of the Attorney General.
May it please the court, my name is Mark Colich. I represent the appellant, Howard Johnson.
Thank you, counsel. Ms. Haskins, you may proceed.
Thank you, Your Honor. Good morning, may it please the court. The present appeal is before you today on a workers' compensation case. Howard Johnson is a delivery driver for U.S. Foods. And on October 16, 2015, when he attempted to open a tri-fold door on his trailer, he encountered resistance to a point that he had to exert some force. This unfortunately resulted in an injury to his neck. The injury was to the degree that he did require surgery, and he treated for some period of time. Shortly after surgery in early April, he felt well enough that he requested his surgeon release him to go back to his full job duties, which Dr. Hess agreed with. And by July 28 of 2016, roughly 6 months after surgery, he was released from all medical care and placed at what is called maximum medical improvement. Because Mr. Johnson was injured at work, his sole remedy in Kansas is the Workers' Compensation Act. He received 3 benefits that are afforded him under the statute. He received payment for the time he was off of work recuperating. He received all of his medical bills paid. And finally, he received an award for permanent partial impairment. Now, the permanent partial impairment is adjudicated by the judge based upon ratings that are expressed by physicians in the case. What's highly unique in this case is that Mr. Johnson's treating doctor, Dr. Hess, as well as his self-selected medical expert, Dr. Koprivica, both gave an identical opinion that his impairment in this case was 6% to the body as a whole. And that's the terminology we use for a neck injury. In arriving at that determination, the physicians used the AMA Guide to Evaluation of Permanent Impairment, 6th edition. And that is the nexus or the rub as to why we are here today. Howard Johnson disputes that the application of the 6th edition of the guides satisfies the adequate substitute remedy or quid pro quo that is mandated by virtue of an amendment to the Workers' Compensation Act. In 1993, the Kansas legislature amended KSA 44, 510D, and 510E, changing for any dates of accident from January of 15 going forward from using the prior 4th edition of the guides to the 6th edition. Mr. Johnson argues that this change has resulted in a diminution of the rating he received, resulting then in a substantially lower financial recovery for him. At the outset, let me start by saying to our viewers that it's axiomatic that statutes are presumed constitutional. That's not to say they are not subject to judicial review, hence why we're here today. But the decision by the Kansas legislature in 1993 to amend our statute was not done in a vacuum. Rather, there were testimony before the legislators from multiple various entities, including attorneys that represented injured workers, along with attorneys that represented employers, labor, and then also very notably medical practitioners. Dr. Melhorn, who's a treating physician in Wichita, testified before the legislature, and he explained to the legislature why he believed it appropriate that Kansas move forward into the 21st century and adopt now the 6th edition, because the 4th edition is by now 27 years old. It was published first in 1993, and it's out of date. He thought, and it was agreed to, that Kansas should be more in conformity with the majority of states that utilize the 6th, if they're a state that utilizes the guides in the application of their workers' compensation acts. What's highly unusual again about this case is that both of the doctors that gave a rating gave the exact same rating. As a work comp practitioner, I can tell you that rarely happens. Generally, the treating physician will give a much lower percentage of impairment rating. The employee and his or her attorney will hire a medical expert then who will give a much higher rating. And the parties then seek to bridge that gap and resolve generally somewhere in the middle of the doctor's opinions. If that gap is too large, the judge has the statutory ability to appoint a court-ordered independent medical evaluator, which is in essence a tie-breaking opinion by a 3rd or even a 4th physician. So by virtue of this entire scheme, due process is served. The employee is given a full hearing on the merits of his injury, and the judge has before him or her multiple medical opinions from which to decide what the appropriate level of impairment is. I see that I'm drawing close on my time, so I just wanted to make a couple of closing comments. First of all, when this case started out in 2015, I can assure you I'd never dreamt I would be arguing before you today. And I certainly didn't think I would be doing so via video conference on Zoom. I don't know about the rest of you, but I hadn't heard of Zoom until 2020. And just as technology has changed and advanced, so has medicine, clearly. I would ask the court to keep Kansas in the 21st century and affirm the use of the 6th edition, and not send us back to using a 27-year-old out-of-date medical text, one that's used by only a handful of states. And while our brethren in those states, such as Alabama and Arkansas and West Virginia, see fit to do as they please, I would ask that you reverse our Court of Appeals and affirm that the Kansas statute amendments at 44, 510 D and E our Constitution as written, mandating the use of the 6th edition. Thank you.
Do you dispute that application of the 6th edition resulted in a lower rating for Mr. Johnson than he would have received under the 4th?
Your Honor, I cannot dispute that. Both physicians testified in this matter, and they both testified that under the 4th edition, their estimate would have been more in line with 25% impairment. So in this particular case, no, I do not disagree that that occurred.
And that's a significant difference, isn't it? Would you say, from 25 to 6?
I would agree that that's a significant difference. In Mr. Johnson's case, it made about a $45,000 difference for him. I think for most people, myself included, I would consider that significant. Yes, Your Honor.
So when we look at the quid pro quo test, the two-prong test, it sounds like much of your argument has gone to the first prong about the necessity or the purpose in the public interest to promote the general welfare, to, as you say, to bring Kansas into the 20th, bring us up to date and no longer using an outdated guide. But how do we balance that with the second prong about providing an adequate substitute remedy to Mr. Johnson when there is such a significant shifting?
Your Honor, I think in part it goes to the fact that in workers' compensation, we are largely driven by our medical professionals. They have said that we need to adopt the more recent medical standards that are set forward in the 6th. Mr. Johnson was still afforded all of the rights he was owed under the Act. His benefits being paid while he was off of work, all of his medical care being paid for, and then ultimately at the end, an award based on permanent impairment. There will be cases where the 6th edition affords a lesser remedy. There will also be cases where it may potentially afford the same or even more, or perhaps none. But as applied to Mr. Johnson, he still had the same rights and benefits afforded to him, albeit at a reduced amount in his case. But I would also point out that with regard to Mr. Johnson, he returned to work doing the same job he was doing pre-injury, albeit with some complaints, obviously, of some pain on occasion and changes in range of motion. But that's specifically why the 6th edition in part was brought to bear, is the 6th edition focuses more on the diagnosis as opposed to the individual's demonstrated range of motion. And the reason that the authors of the 6th went to that is because we understand range of motion is a highly subjective outcome, if you will. If a doctor tells you to move your hand a certain way, you respond, but only you truly know if you're giving full effort. And so by going to the 6th, we sought to more standardize and take into account the diagnosis in arriving at the ultimate percentage.
I will try to ask this question of all counsel, but I would like to make sure you have a chance to answer this. Do we just focus on the change in the statute that brought about the 6th edition? Or do we look more globally at the changes that really have occurred since Shade, the first decision, finding that the adoption of the Workers' Compensation Act as a substitute remedy, and do we accumulate all of the changes that may have impacted a worker in Mr. Johnson's position to see if, given all of those changes, there remains an adequate remedy? Or are we limited to just looking at this question about the 6th edition?
Well, Your Honor, that it's a difficult question, and it's a difficult balancing act. I think on the whole, we do have to view it as a whole because it is a statutory schematic that injured workers have to fall into if they're injured at work. It's their exclusive remedy. So I think history is some guide for us. But by the same token, I don't think we necessarily can go line by line through the act and weigh pluses or minuses for each side. Just as the changes in 1993 went to the 6th and arguably harmed, especially Mr. Johnson, but arguably harmed other workers, there were other amendments, though, that enhanced benefits for injured workers. And so those should be taken into consideration as well. So I think realistically, we have to look at it globally as an entity, as an entire act.
Counsel?
Yes, Your Honor.
Could Could the rating have been 25% based on Dr. Hess's opinion, notwithstanding the 6th edition under KSA 44510?
Not as presently written. Dr. Hess testified because he was mandated to use the 6th. In his medical opinion, it had to be a 6% impairment rating.
So your interpretation or construction of that statute does not leave room for independent medical opinion that may be in conflict with the 6th edition?
Well, what I would say is my interpretation of the statute is it still falls to the medical professional to use his or her education, experience, and expertise and analysis of the 6th to come up with the appropriate rating. It is highly unusual that both doctors come up with the exact same rating. So I would dispute Mr. Johnson's contentions that there is no room for variation in the ratings. There clearly is. That falls on the medical professional to analyze and apply the guides. That's why they are asked to bring those opinions to the judges for their consideration.
But at the end of the day, was a 25% rating supported by, would that have been consistent with the current statutory framework?
According to the physicians, no, Your Honor.
Thank you.
So,
Other questions?
counsel, we're here because of Section 18, which guarantees a remedy by due course of law, correct?
Correct.
And our court has said in the past that by itself, which is similar to the due process clause, is not in itself a fundamental right.
Correct.
However, one of the quid pro quo that has occurred with the Work Comp Act was the essentially giving up of the right of trial by jury, which is guaranteed under Section 5 of our Constitution, right?
That's correct, Your Honor.
That is a fundamental right, correct?
Yes.
So in analyzing any quid pro quo, would you agree you have to balance in that giving up the fundamental right of not having a right to jury?
I think the comparator in this case is whether the quid pro quo exists as a compromise between the employees giving up the common law right to sue, including potentially a jury trial in comparison to the act. Yes, Your Honor, I would have to agree with that.
Thank you.
Are there other questions of counsel? Mr. Carswell.
May it please the court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of Intervenor, the state of Kansas. The Court of Appeals made 3 fundamental errors in declaring the adoption of the 6th edition unconstitutional. First, the Court of Appeals misconstrued KSA 44-510E to exclude the use of competent medical evidence. The better reading of the statute would preserve the use of competent medical evidence and simply substitute the 6th edition for the 4th edition. Even if that weren't the best reading, it's certainly a plausible one that the court should adopt if there are constitutional concerns with an alternative reading. Second, the Court of Appeals ignored the fact that the legislature based the adoption of the 6th edition based on the testimony of medical professionals that the 6th edition represents the most current medical understanding of impairment, while the 4th edition is outdated. The Court of Appeals said that only went to the first prong of the quid pro quo inquiry, but that's not correct. It goes to the second as well. Obviously, to the extent that the 6th edition does in fact reflect current medical understanding, it can't be said to provide an inadequate remedy. At least, and certainly not across the board. The Court of Appeals declared the statute facially unconstitutional, or this provision facially unconstitutional. Even if there are problems with the 6th edition in terms of, and we don't think there are, but if there were, with respect to certain ratings or types of ratings or whatever, there's certainly been no showing that it's unconstitutional across the board. The Court of Appeals focused on the definition of the term impairment rating in finding that this is unconstitutional and said that that excluded any kind of work activities. That's not correct. The definition of impairment rating is a consensus-derived percentage estimate of loss of activity for reflecting severity for a given health condition and the degree of associated limitations in terms of activities of daily living. So it's not exclusively about the activities of daily living. And even then, the activities of daily living, there is a table that the Court of Appeals referred to, but that's not an exclusive list. In fact, there's another table in the guides, table 1537, that talks about other activities of daily living, such as standing, sitting, walking, lifting, that are all relevant to work. So it's simply not the case that the sixth edition is not acceptable for determining work impairment. In fact, the sixth edition itself recognizes that it's often used in workers' compensation statutes. There are a number of states, I think around 19, that use it for that purpose, including in the federal government as well. And then before the Kansas legislature, the Kansas Medical Society testified that the sixth edition should be adopted. So the medical professionals, the group that represents them in the state, deemed that this was appropriate, and the legislature reasonably acted on that.
Counsel, before you run short of time, you mentioned the quid pro quo test, and I want to ask a couple questions about that are somewhat more theoretical about the quid pro quo test. And my first question would be, does the state believe that, or is it the state's position that the quid pro quo test this court has adopted with respect to Section 18 is consistent with the original public meaning of Section 18?
No, we do not think that. So we discussed at length in our brief in the Hilburn case. If you look at the original public meaning, the phrase that's in the Section 18 originally goes back to the writings of Sir Edward Coke on the Magna Carta, and specifically what he was referring there to were procedural rights. In fact, he used the phrase, no subject of the realm shall be denied his remedy. So it's referring to the remedy that's provided by law, it's not a substantive entitlement to a remedy.
If I could restate it, would it be consistent with the state's view that Section 18 and similar provisions in other state courts were intended to guard against interference with the administration of those remedies, as opposed to locking in place the substantive content of the remedies?
I think that's absolutely right. And in fact, if you look to the text of the amendment, the title before it is Justice Without Delay. So it's about how justice is administered. It's not about substantive entitlements to remedies.
And then my last question on this line would be, at least some members of this court have determined that the quid pro quo test is not appropriate in the context of Section 5. And in fact, at least as of now, that's the prevailing law in Kansas based on the Hilburn decision. If that remains the prevailing law, would there be any reason to apply the quid pro quo test to Section 18, but not to Section 5? In other words, is there any way to distinguish those two provisions of our Constitution that would make some coherent sense with respect to the quid pro quo test?
Well, this court's precedents have not followed the original understanding as we understand it, and they do establish this quid pro quo test. And I think if you assume that Section 18 does provide some substantive entitlement to remedy, the quid pro quo test is at least one way that Section 18 can be satisfied, and that's the way we believe.
Right. However, is that consistent with the majority? Does the state have a view as to whether or not that's consistent with the majority's conclusion in Hilburn that quid pro quo does not apply to Section 5?
I think it is consistent because Section 5 and Section 18 address pretty different things. Section 5 is about who decides. In fact, Hilburn recognized that the state could, or the legislature could abolish causes of action, just a matter of if there is a cause of action, who determines damages, for instance. Whereas Section 18, if you read it as this court's precedents have, there's a substantive right to some remedy, and quid pro quo is at least one way of satisfying that in the way that we believe has occurred here.
May I follow up on those concepts a little bit in terms of the historical context? Lord Coke greatly expanded the original Magna Carta provision in a way that would be binding on King John, right? Which is equivalent to the legislative power at the time. But even more recently, isn't there evidence that this remedy provision was adopted in sort of a second wave of state constitutional provisions in response to a perceived overgrant of legislative power?
No, I'm not aware of that, at least. My understanding is, I mean, you're right, Lord Cook definitely expanded it somewhat, but yeah, I'm even looking at his statements. What he was clearly talking about was a procedural right. And then early states put that into their constitutions, and it was copied from constitution to constitution. Ours came from Ohio, I believe. But I'm not aware of any evidence that it was meant to expand a substantive entitlement to right. In fact, as I mentioned, the title itself suggests that it's a procedural mechanism. But
And if that evidence existed, would it be relevant in deciding whether or not the intention of that provision was substantive or procedural?
it might be. I mean, my one hesitation there is that I looked at the Constitutional Convention in Kansas. There was nothing on this provision, so I don't know that you can say anything about the Kansas Constitution founders' specific intent. So, but if there were evidence that I'm not aware of, it could potentially be relevant.
Okay. And one final question, back to your first issue on the statutory interpretation. Are you suggesting that there is room for the physicians to do an independent rating, even if it's not consistent with the 6th edition's recommendation?
I think at minimum, that's at least one plausible reading of the statute, especially given the term based on and how that could be read. And so if there are constitutional concerns with relying strictly on the 6th edition, I think in terms of constitutional avoidance, the court could give the statute that interpretation of saying, well, you start with the 6th edition. That's kind of like how a sentence is based on the federal advisory sentencing guidelines. And as we know, there's a case about that. And so you start with that, but then if there's competent medical evidence that in reality it should be more, you could go to that. Now here, there's a question about how the 4th edition allegedly would have provided more compensation. That doesn't necessarily mean that compensation was required by Section 18, but you need to compare in doing the quid pro quo analysis is the remedy available at common law with the current remedy. You don't focus on the change from the 4th to the 6th edition, which the Court of Appeals improperly focused on. In fact, the only evidence here really about how this relates to any kind of common law remedies is Johnson's own admission in his supplemental response brief that the compensation he received under the Workers' Compensation Act actually exceeded his economic loss. Now, he claims that he would have had non-economic damages at common law, but that's a trade-off. You get rid of those and you get the fact that you don't have to prove negligence or fault. You don't have contributory negligence, assumption of risk, things like that. In fact, here, it's very unlikely that at common law, Johnson would have recovered anything just because the pulling on the frozen freezer door is unlikely due to negligence of his employer. So in reality, he probably went from 0 to the compensation he received. Certainly, the compensation he received covered all of his economic loss. And then again, he's back to work. Is not having any ongoing work compensation loss.
Counsel?
Yes.
Very briefly, excuse me, Your Honor.
Go ahead.
We all know that tort rights are fundamental rights, correct?
If you're talking about fundamental rights in terms of
the
due
right
process clause, I think that's too general.
Well, common law damages, right to jury trial, those kinds of things. Those are fundamental rights, aren't they?
I think if you're getting specifically to like the presumption of constitutionality, what that's referring to is there are certain fundamental rights that are so deeply rooted in our history and tradition that they can't be abolished, at least without strict scrutiny. So it's right that there's a constitutional right to a jury trial, which is.
So those would be among them, correct?
There is a constitutional right to a jury trial, which is not implicated here.
So if the original bargain, if you will, and the court repeatedly gets into this quid pro quo analysis, what you gave up, what you get, et cetera, you don't have to prove liability. It's almost like insurance, et cetera. If that original bargain, if you will, started out with constitutional rights to a right trial by jury, to have a jury to decide damages, those kinds of things, and then over time, those rights are eviscerated through administrative procedures. Isn't there a point where essentially the quid pro quo becomes an imbalanced exchange such that it no longer makes a lot of sense from a fair standpoint of the trade-off for an injured worker versus the industry that seeks to adopt administrative method for determining it by adopting such the AMA guidelines?
It's certainly true if you, accepting injured workers as precedent. Yes, there's a point at which compensation could be unconstitutional. We don't believe that's happened here.
Did the early forms of the workers' compensation scheme adopt medical journals or administrative handbooks? When did that first start?
Yeah, I'm thinking it was with the third edition, sometime maybe in the 80s. That's to the best of my recollection. I think it was the third edition, then the fourth edition. We went to the sixth edition. I couldn't say with 100% certainty.
Okay, thank you, counsel.
Sure.
I'd like to return to the line of questions about the historical development of Section 18. I think you may be right that there's little guidance for us in the debates at the Constitutional Convention. Is there any guidance for us in our early case law? Can we discern that, is it fair to discern that the early Kansas Supreme Court had an idea of what might have been in the minds of those who voted on the Constitution? And do we give extra weight to that? Or is that just no more than one other case in the stream of cases from our court?
I'm not aware of any cases that could be described as contemporaneous, at least to the extent that maybe there was some understanding at the time.
I think the Hansen decision and 3 Can App is perhaps the first of the decisions. So it's relatively contemporaneous.
I can't say I'm particularly familiar with that, but I don't think it's necessarily controlling by any means. I mean, again, the question is what this originally meant at the time of the founding. And it's pretty clear that this precise language was copied from earlier constitutions that trace back to Clerk Cook, and that was a procedural right. And again, the text of the provision itself, I think, indicates this is a procedural right.
And it's not fair to ask you about that case since it hasn't been cited and you're not familiar with it. I do read it as, personally, as giving an individual right, protecting a right for beyond remedy of substantive rights. But that may be up for debate. So it's not entirely clear. But anyway, I think you have answered the question I had posed to Ms. Haskins, which is that we really should go back from the point in time when the common law remedy was replaced by the statutory remedy and look to Judge Haubert's point, over that period of time, has it become so weakened that the remedy that might have been sufficient at that point may now not be? Is that fair?
I think that's correct. You certainly look at the act as a whole. Now, the one qualification to that would be if you're talking specifically about the 2011 amendments that were discussed in the Court of Appeals opinion, there's been no constitutional challenge to those. So I think the court does need to presume that those are constitutional. But again, that's just part of assessing the change from the common law to this act as a whole, yes.
And then finally, I think it's fair to say that we don't have a lot of case law applying the two-pronged standard of the quid pro quo test. And so it's not eminently clear to me exactly how those two prongs become applied. This goes a little bit, perhaps strongly, to Justice Steagall's dissenting opinion in Hilburn and Justice McFarland's opinion that he cites to in that. And how do we look at those two prongs that are joined with an and? So we know it's not an either or, but how do we balance, if at all? Is there a balancing of those two? Is it that one is a threshold to get to two? And how do they work together, I guess, is my question to you as you read the Kansas case law.
As I read it, I think it's an alternative test. You could fail either prong, in which case it would be unconstitutional. Of course, the first prong is essentially just a rational basis test, which applies even outside the context of Section 18, arguably at least. And so again, that's a pretty easy prong to get by. And I think really the focus is the second prong. Now on the second prong, I mean, it again, the Court of Appeals of this evidence about what was before the legislature and the fact that the 6th edition is based on current medical science only went to the first prong, and we disagree with that. We think it goes to both, as I explained, but I do think they're alternative inquiries.
And so that if one can outweigh, two can outweigh one, but one can't outweigh two, is that what you're saying? I'm not sure.
No, I'm not saying it's a balancing test. I'm saying basically you have to satisfy for a law to be unconstitutional, since the burden's on the challenger. They have to show that it fails one or the other test. Either there's no rational basis or it fails to provide an adequate quid pro quo for the common law remedy. Assuming that's, again, the test.
All right, thank you.
Sure.
Other questions? Mr. Judge Hauber? Yeah.
I'll try not to beat a dead horse from my one opportunity of appearing with the Kansas Supreme Court, but counsel, under 42 USC Section 1983, which is basically the equivalent, the due process rights are under the 14th Amendment are the equivalent of Section 18, correct?
I don't actually think that's correct. Now, there's a fact that in Johnson's brief, he mentioned the 14th Amendment, and the Court of Appeals did as well, but the analysis, I think, was exclusively Section 18 of the Kansas Constitution.
Fair enough. But if we look at due process as carrying along the analysis of the right that's at stake, under this quid pro quo analysis, the first prong has to be tied to the hip to the right that's at issue. Don't you agree?
I'm not sure I follow the question. Under the first prong of the the Section 18 inquiry, it's a rational basis test, which, yes, is similar to, I suppose, substantive due process.
But if you're giving up a fundamental right, it's not a rational basis test. It's strict scrutiny, isn't it?
No, that's not correct. In terms of, if you're talking about the 14th Amendment, what you need to look to is the right at issue. So here it would be the common law right to sue your employer in tort. And then the question is that so deeply rooted in our history and tradition that the legislature can't abolish that? And they have. So it's clearly not. I'm not aware of any federal case law saying that violates the 14th Amendment.
But the common law allowed a right for trial by jury, the right to cross-examine doctors, to get to the foundation of their opinions, all that, right?
Section 5 of the Kansas Constitution does protect a right to trial by jury, but in the state's view, at least, that's not a substantive entitlement to a cause of action. That's a question of if there is a right, who decides, essentially.
That's part of the remedy. Your remedy is you get to go to a jury and you get to lay all this out, and you get to cross-examine those doctors, whether they're pro-industry or whether they're treating doctors, to find out if they have a bias and whether or not the remedy that's being offered is fair.
I would not describe any kind of constitutional right to sue the employer in tort as being a substantive, fundamental right under substantive due process.
All right.
I'm not aware of any case for purposes of the 14th Amendment. Now, I think it is protected under, at least under this court's precedent, under Section 18, and what's required there is an adequate substitute remedy for that. Unless there are any further questions. Thank you.
Thank you, Mr. Carswell. Mr. Coley?
Thank you, Your Honor. As I mentioned earlier, my name is Mark Colich. I represent Mr. Johnson. Preparing for this argument, I read through all of the briefs. There are many. They basically all say the same thing as to what the law is. But then it occurred to me that the best argument I read was written by Judge McEnany. It's a very thorough, well thought out opinion. And Chief Justice, you asked a question before about whether or not we should just look at the 6th edition statute or the entire act, in particular the recent amendments in 2011. I think it's pretty clear that Judge McEnany thought that this should be looked at globally rather than an isolated statute. And it also occurred to me that I don't see that there could be any reasonable issue taken with an appellate decision that makes reference to Monty Python's Black Knight. That has to be a one of a kind. But before I go any further, Justice Wall asked a question about ratings and whether under the current statutory scheme, the doctors or the ALJ could have awarded more than the rating provided by the 6th edition. I'm not sure Mr. Carswell knew the answer, and that's really not his fault. I don't think he practices in workers' comp law or ever has, maybe. At any rate, the answer, Justice Wall, is no. The law as written says the rating has to be based upon the 6th edition. Now, there's been some suggestion by the Attorney General that that's a starting point. No. The way the law is administered, and I've been doing this for 41 years, whatever the edition, whether it's the 4th or the 6th says, that's what the award is going to be. The physicians are not free to just say, well, this is a starting point, but I think there's more. It doesn't work that way. This man was going to get 6%, and that was the end of it. Now, as far as the quid pro quo is concerned.
Counsel?
Yes.
Before you move on from that point, so I'm understanding that, but is there room within the statute to construe it as allowing for that physician discretion to use it as a starting point? I understand in practice, it sounds like it's not ever interpreted that way, but should it be?
Well, I think the answer is no. And the reason being, and the Court of Appeals pointed this out, that when the statute was amended, the first part of the statute says that the rating is based upon, or to be based upon competent medical evidence and based upon the 4th edition. And then it goes on and it says, but if you get hurt after January 1 of 2015, it's based on the 6th edition. They dropped the language competent medical evidence. And so I think the Court of Appeals rightly said, well, that's a problem, because now you're really just stuck with this book. And by the way, it's probably wrong to use guides to award compensation injured workers anyway, because it's the name of the book is guides. We shouldn't be stuck with it, but that's the way it's done. At any rate, the way the statute is written, 6th edition is not, we don't have any leeway of competent medical evidence. We're just stuck with the 6th edition.
Okay. Yeah, so you're saying that last clause in subsection 2B doesn't simply modify the entirety of the previous language. It eliminates the physician discretion altogether.
I believe that's true. And I know the Attorney General argued in its brief that, well, you can actually interpret the statute to put that part back in, but this court's decision in Casco versus Swift-Eckridge makes it clear you can't add to the statute, the language of the statute, you can't take it away. So I don't think that's a valid argument that they made.
Counsel, can it be argued that the 6th edition is based on competent medical evidence?
No. The 6th edition is not based on any science. It is a consensus of opinion of a small group or committee of doctors, most of which have an insurance company bias. And further evidence of that is that in this case, the treating doctor, a board-certified neurosurgeon, testified that the 6th edition allows a 6% rating, whereas the 4th and as well as all previous editions would have given a minimum of 25%. But the important thing is the doctor's testimony that 25% is more representative of his true impairment. The doctor also made it clear that he has been doing neurosurgery for 20 some years. I forget exactly, but there have been no technical advances it's done, the cervical fusion is done the same way now as it has ever been. The only difference was, I think, he said in the 90s, they started using metal plates to stabilize the vertebra. But this whole notion that there's been medical advances and that justifies the sixth edition, that's all smoke and mirrors. It's none of that's true at all. I think the true reason that the sixth edition ratings are lower across the board than, and they're not just lower, there's testimony in the record that they are 40 to 70% lower than the earlier editions. And I think the real reason is that the authors of this book changed the way they defined impairment. Because now, under the sixth edition, if you read their definition, and as pointed out by the Court of Appeals, impairment has to do with the activities of daily living, but there are things such as eating, personal hygiene, toilet hygiene, sleeping, sexual activity. There's no mention of any work activities at all. Whereas under the fourth edition, it also based impairment on activities of daily living, but work activities were included in the definition of activities of daily living. So a gentleman such as Mr. Johnson, who, by the way, this is a serious injury. He had spinal cord damage, actually. Unfortunately, was stabilized by the surgery, but he's able to take care of himself. He can eat, he can sleep. But what is the problem he's going to have is with activities of working. He can no longer perform unrestricted activities of lifting, bending, all those things. So that's the real issue. And when you look at the Supreme Court decisions, they say the purpose of the act is to restore lost earning capacity. So how do you do that? By measuring impairment by the ability to sleep or eat. Makes no sense. So this whole notion that the sixth edition is we're going to bring us up to date in the 21st century. No, it has nothing to do with that. The sixth edition has to do with the Chamber of Commerce wanting to keep costs down in workers' comp matters. We can all make up reasons why this happened, but everybody that in the know knows that's what happened. That's what they wanted to do, and they've done it. So there's nothing really good to be said about the sixth edition. Now, they will say that, well, other states use it. Well, some other states do use it, but no other state uses the sixth edition and also the standard of prevailing factor, which was put into law in 2011. Now, prevailing factor, it used to be that the causation requirement in workers' comp is that there was a reasonable connection between an injury and employment. Now, we have to prove that an injury is compensable only if the employment was, or the injury was the prevailing factor the employment was the prevailing factor for the injury and resulting disability. And the problem with prevailing factor is then they had to define what prevailing factor meant. And they defined it as a primary factor in relation to any other factor. Well, the problem with all of that is that it's been used, or it's a real problem because we have an aging workforce that people wear out over time. They're performing physical labor over time. They develop degenerative changes in their back, arthritis in their knees, but they're having no pain. They're functioning on a regular basis. And then they have an on-the-job injury, and these underlying conditions that have developed over the years from doing work now becomes symptomatic and disabling. But under the prevailing factor standard, they're not compensated because the doctors will say, well, they're having pain, but the prevailing factor is the underlying degenerative change. And you put that together with the fact in 2011, the legislature did away with case law that was on the books from the beginning, that an aggravation of a pre-existing condition is compensable. So now we have a law that makes it not only much harder to get compensation, but when you do, you don't get much anyway.
Can you steer us then? You've made these observations about the 6th edition, very compelling observations. How is it that we get to the point, or what's your argument that we've reached the point that that's basically emasculated the substitute remedy?
Well, Your Honor, that is very.
How do we? Isn't that the question? That's really what you're asking, isn't it?
That is precisely what I'm asking.
And so how tell us how we get there and how we do that.
I'll try. So in the Franklin case, as you recall, at issue was some statutory amendments made in 1993. And the issue was whether or not those amendments emasculated the quid pro quo. And the court went through a very detailed analysis of each statute, and then simply at the end said, but we don't think the act's been emasculated. So I don't know if it's or the quid pro quo has been emasculated. So I don't know if it's a proper comparison or not, but it seems to me that it's a lot like the definition of pornography. Nobody knows how to define it. It's one of those things the court has said, you know, when you see it. And I think that's the deal. You just have to look and see, have they gone too far? And that's what Judge McEnany did. In fact, back in the Franklin case, Justice Allegrucci thought in a dissent that the legislature had gone too far, and he questioned, boy, if they haven't gone too far now, what's it going to take?
To that point, counsel,
yes,
that point leads directly to the question that's been percolating in my mind, which is, at least to date, my reading of the case law is that the Kansas Supreme Court has never seen a quid pro quo that it didn't like. And so my question is, are you satisfied with the quid pro quo test?
I'm sorry, Justice DeGaulle, this technology cut out. Could you repeat your question, please?
Sorry about that. Problem may be on my end. As you were discussing the sort of, you know it when you see it, my reading of the case law suggests that every time the Kansas Supreme Court has been asked to determine whether or not there was a sufficient quid pro quo, the answer's almost invariably been yes. And so I'm just curious if you're satisfied with the quid pro quo test. It seems as though if Section 18 freezes a substantive right in place, that you might be arguing that, hey, why should the legislature get to take that away at all, even if they give us an alternative remedy?
I'm not sure this answers the question, but it seems to me that if that was the approach taken, the entire act would have to be deemed unconstitutional. And I'm not asking.
Are there other questions? Okay, I thank you, Mr. Coolidge. Mr. Carswell, you reserve 3 minutes.
Thank you. Johnson argues that the 6th edition isn't based on medical science and is just written by biased experts, but it's put out by the American Medical Association, not some fringe group. And even here in Kansas, it was the Kansas Medical Association, a statewide organization that represents physicians, that advocated for its adoption. There's certainly been no showing that it's problematic overall, much less even in this case. There is one case that the amicus brief from the American Property and Casualty Association cited that I'd like to specifically bring to your attention. That's the Thompson versus USD 512 case. That was when the 4th edition was still in place, and the 6th edition had already been released but not adopted. A claimant argued that the 4th edition in that particular case was not correct, and the doctors testified to that and argued for compensation under the 6th, which was actually greater in that case, as well as other factors and things. And the Court of Appeals rejected that and said, no, you've got to use the 4th. And so that's an example of a situation where the 6th edition actually provides more compensation. And at least according to the doctors there, is more accurate, which again, the medical professionals here testified was true of the entire 6th edition. So certainly at minimum, you should not find the 6th edition to be facially unconstitutional. To the extent there could be a problem, which we don't think there is here at least, that would need to be based on the specific rating and testimony of medical professionals that there's a problem with this rating, not that the entire thing's invalid. One other point in terms of the remedy, I wanted to mention that specifically. To the extent you find there is a problem, in no event should the remedy be returned to the 4th edition. Again, that's outdated. In fact, it's not even in print anymore. It provides less compensation in some areas. The best remedy, we believe, would be to keep the 6th edition and just say that doctors can deviate from that, assuming you can't get there by statutory interpretation, which we believe you can. In reference to Justice Wall's point to Johnson, the based on phrase in the statute, I do agree with Johnson that probably the legislature's intention there was to use the 4th edition, or excuse me, the 6th edition exclusively. But to the extent there's any constitutional concerns, I certainly think that based on language could be read more broadly than that to allow, again, as the term based on has been interpreted in the sentencing guidelines at the federal level, to allow that as a starting point. The 6th edition is a starting point, but then saying you can deviate.
Counsel, can I ask you are you familiar what's happened since the 6th Amendment was incorporated in terms of overall cost of claims to employers?
I am not specifically in Kansas. Now, there was evidence before the legislature that overall compensation under the 6th edition is not, on average, is not substantially different than the 4th edition. There were some areas where it was less, in part because of advanced medical knowledge and advances in medical science, but there were other areas where there was greater compensation. And that particular study, which was put out by the American Medical Association, found that there was not a significant difference on average. And then, of course, the question is not whether the 6th edition provides less money than the 4th edition. It's how it compares to common law. And central to that is the fact of whether the 6th edition is medically accurate. So even if the 4th edition provided more compensation, which hasn't been shown overall, if that wasn't medically accurate, and if there have been medical changes, the 6th edition, even if it did provide less compensation, would still be constitutional. See, my time has expired. Unless there are any further questions, I'd just urge you to reverse the Court of Appeals. Thank you.
Thank you, Mr. Carswell. I don't see any other questions with that. So I would like to thank all counsel for their arguments. The court will take this matter under advisement. We will be in recess until 9 a.m. tomorrow morning. Thank you.